just following the election when you went to Star Township, when you went to Mansalona Township, and by you, of course, I mean your client or your someone on your behalf. When you went to Central Lake Township, uh, so the basis, if I understand your argument, is the Halderman report for the information you're seeking?
Well, I think that's certainly one basis for the information we're seeking. We're also, we went out and we retained additional experts, Jeff Lenberg and Jim Penrose, who have done additional work in order to refute the Halderman report. So that's part of the basis. But certainly the other basis within which we seek to do this is the relief we requested within the complaint itself. The relief to have an independent audit conducted in this case. But the Halderman report suggests that there was no problem with this election. And since we received the Halderman report and the additional testing we've done, we've discovered multiple problems with this election that actually occur at the tabulator, as we showed the court and many other people in the video we released last Monday that we linked into in our brief, where we can flip votes at the tabulator. We show people how that can be done, whether it's the presidential election all the way down to any proposal in this case, any of the township elections or any of the school board elections. We can flip votes up and down the ballot as we choose, based only on the information and the programming that's available to us on the Dominion system, including this unauthorized Microsoft SQL database management program. So we show that we can do that. And then today we filed a brief with the court where we showed exactly how the fraud occurred in this case. Certainly the video we released last Monday shows that there is potential for fraud. The video we put out today shows the actual subversion of the vote and how the fraud actually occurred within each of these townships. And that's something we should be able to look at and examine. The court has to be conscious of the idea that we've been seeking discovery from the defendants since February 8th, 2021. And in each of those requests, the second, third, fourth, and fifth discovery requests, the plaintiffs have continuously made objections, filed motions. We still have not got answers from them regarding those discovery requests. We had to submit additional or amended discovery requests, which would be due today. So we've done all this work discovering what we've discovered, even without the help of the discovery responses from the Secretary of State or Antrim County. So really, I think the question is not why this has taken so long by us, but we have to look at, number one, the idea that the defendants have consumed almost the entire part of discovery by delaying. But I think the real question is why are we rushing this? We've recognized that we've discovered so much in this very short period of time. There's so many layers and layers to how this fraud occurred, what happened in Antrim County, and we now can definitively show the court that the fraud actually occurred, and it really debunks the Halderman report. There's no way that report would be correct. There's no way that the votes are transferred from Jorgensen to Trump to Biden, and then Biden's votes disappear. We show that now forensically and through our scientists who say, if that happened, as the Secretary of State and County Clerk Cheryl Guy claims it happened on election night, the system would have shut down. There would have been a critical error. That didn't happen. There wasn't a critical error. The results, the election actually continues which shows behind the scenes the subversion and how the county, the Secretary of State, and maybe even the townships were able to manipulate the transfer of those Joe Biden votes to an undervote category. That does not happen in the normal programming of this system, and that's the subversion we've uncovered. We absolutely have to be able to go in and look at the township records, look at their machines, look at their ballots. It's critical to the case. We shouldn't be rushing a case that is as important as this case is, considering all of the information that we have discovered. We also showed the court that what we discovered just recently is that in these individual townships, we provided the court with graphs for every individual township. We now show that in the age categories of 65 to 80, there is almost a 100% voter turnout in those categories. We don't believe that that is accurate. And we also show this high rate, 20% of absentee ballots that were mailed out were actually mailed out to P.O. boxes, which is illegal. Then in terms of the other arguments by the townships, this idea that this is so burdensome to them, they already did this on December 17th when they brought their ballots to the Kearney Township Hall. No one seemed to complain then that was a problem. And we've addressed their other concerns as well by providing the qualifications of these expert witnesses. Certainly if the court wants to question them and vet them, the court can do so. And we'd even provide the opportunity for these township attorneys to voir dire our experts. And finally, in terms of the cost, as we've stated, plaintiffs certainly willing to share in the costs that the townships would bear. We have no problem with that. And then I should say finally now, the other issues raised by the townships is the possibility that their contracts could be voided or warranties voided, or that these machines could no longer be used. That's just not true. There's no indication that anything would happen to the machines. We're not going to decertify the machines. In fact, when these experts perform any forensics on any machine, they install a baffling device that doesn't permit data to go back upstream into the machine. So that's just low-hanging fruit and not accurate. And then the issue of any other destruction of information, it's just not accurate or true. That's not going to happen. So everything here can be protected. There's no chance that we're going to damage anything of the townships. But even if it's the case, we'd be willing to put up a bond to cover any potential costs that they might perceive. But I don't see how it would happen. Any questions for me?
All right, thank you, Mr. DePerno. I don't have any additional questions. Let's go back to Mr. Grill in response, please.
There's a lot to unpack there, Your Honor, that we heard for the first time today. I was just scanning through Mr. DePerno's response to our motion for protective order, and I honestly didn't see any reference to Professor Halderman's report in there. But I have to say, I don't understand how any of this could be responsive to Professor Halderman, since Professor Halderman's report made no reference whatsoever to tabulators in the townships. His review was limited to the forensic image that plaintiff took of the master tabulator at the county back in December. So the argument there that we need this to rebut Professor Halderman, well, no. You want to say that Professor Halderman's methodology was wrong, you have his report. You want to say that his results were wrong, you already have the forensic image that he used. This would be an entirely new thing to say, here's some other reason, some new theory that contradicts what the Halderman's report is based on because of new information he didn't have. That's not a rebuttal. That's a whole new thing. Beyond that, I would also note that none of what Mr. DePerno just talked about is anywhere located in the complaint. which is probably something we're going to deal with more closely in the next couple motions. But it certainly presents questions as a basis for why we would conduct discovery on these bases in this complaint as it currently stands. Lastly, and if the court needs additional information on this, we're happy to provide it following today's hearing. But as Mr. DePerno says, this wouldn't destroy the accreditation of the machines. And I have to say that that is not my understanding. Access by non-accredited persons to these machines does conflict with their certification. And while Mr. DePerno may be perfectly willing to assert that nothing bad will happen, that's not how accreditation works. That's not how certification works. They can promise they're not sending anything back into the machines, but it's hard to know for sure. It requires basically the machines to be completely reformatted, taken apart, and set up brand new again, because otherwise we don't know what was added to those machines when Mr. DePerno's crew took a look at it. We can't be sure. So that would create a problem as well that I think would, it's hard to redress in advance. So there are a lot of problems here, but again, I kind of circle back to the idea of this isn't rebuttal. This is all stuff that if Mr. DePerno thought was important to this case should have been done way, way, way long ago. Certainly not until after discovery closed. I would also note that Professor Halderman's report was released to plaintiff on March 26th, I believe. Why it is that several weeks later, Mr. DePerno thought, well, now it's time to go searching for subpoena documents. It seems to me that if this were a true rebuttal to Professor Halderman's report, we would have heard about it much sooner.
Mr. Grill, as to the decertification issue, which is something that we really haven't talked much about, except as it related to the initial inspection of the county machines, were the county machines decertified as well?
There were concerns, Your Honor, and that was part of a problem that we had leading up to the May 5th election. Was what do we do with those machines? We need to use them obviously for the election, but we also, these machines have been accessed, so we need to reformat them. But then reformatting would involve issues whether or not we're destroying or documents are being protected. I would yield to Mr. Chasm as to how the county resolved that. But it is a problem that when you let people who are not, especially in this circumstance, that since we don't know who Mr. DePerno was talking about bringing in, what their accreditations are, and it certainly doesn't sound like they're one of the federally certified accredited inspectors. So that is kind of the problem that we run into.
All right, Mr. Chasm, why don't you go ahead and respond if you would, please?
Just on the issue of with response to your question, Your Honor, the machines, to my knowledge, have not been decertified. However, there were significant concerns regarding their integrity going into the May 4th election, and there were discussions at the county level about bringing in a third-party vendor to reformat that machines while taking all the appropriate and necessary steps to preserve the existing information that was on those machines in accordance with the court's previous orders. Ultimately, the county board decided not to retain the services of that vendor. So, to my knowledge, the machine that is in the county's possession, and I want to make that clear as well, the county actually only has one tabulator. And as the court is aware, that tabulator, the county loans to other townships if they are having some equipment malfunctions or problems. But the county itself doesn't have a tabulator that is that are being used in different precincts in different elections. So to that extent, but the county does have an EMS terminal that was accessed. And to my knowledge, though that was not reformatted because that ultimately the county decided that it wanted to go along with the court's previous orders of preserving the evidence in this case, and we didn't want to be accused of any spoliation arguments down the road.
All right, I appreciate that. I don't want to get too far down that issue, but we certainly have dealt with the issue of Dominion being involved in notifications to, in particular, the county about whether or not there would be issues regarding certification before. I appreciate the parties updating me. Let's go ahead and get a response from Mr. Wendling to Mr. DePerno's argument, please.
Thank you, Your Honor. Again, this complaint filed back on November 23rd asks for, uses the word immediately, to take a forensic image of the 22 precinct tabulators. The first discovery subpoena received by non-party townships was April 19th. So the immediate need due to plaintiff's actions obviously is not as represented in the complaint. Also, the townships are looking at protecting their own equipment. They are not just risk averse, they want to eliminate any possible risk related to the integrity of their equipment, their ability to use it. They've received these through a mixture of grants, through purchases, and they don't want to have something that will result in that equipment becoming voided, unusable for any reason. And that's why it's so important that the court, in my request, if the discovery is to be had, takes the lead, both in determining what is a proper amount of a bond or irrevocable letter of credit to replace any of this equipment should it be destroyed as a result of discovery or otherwise rendered unusable, and also on top of that, for the court to vet who the proper expert is to take a look at this, or experts to look at this equipment should this discovery be had, not just individual attorneys for each of the townships. This letter from Dominion, which is a customer notification, makes me wonder whether Dominion really should have been a necessary party to this litigation, because there's a lot of keys that they hold that can cause a lot of harm potentially to the individual townships here with respect to the equipment. And it is, they're very clear about who is supposed to be qualified and who can look at these machines. And therefore, on behalf of the townships, if the discovery is to be had, we request that the court vet any experts and if necessary, have contact with Dominion to ensure that these experts are qualified to look at this equipment. And of course, the financial protection of the townships, again, should this equipment be otherwise compromised. But the primary position is, I think, given what I've seen of the case, and obviously I'm a non-party here representing non-party townships, at this late stage, I just don't see the viability or the necessity of this discovery, and I would reiterate our request that the discovery be quashed. Thank you.
Mr. Wendling, you had indicated in your brief, I believe, that there might be a difference between the positions of some of your clients versus some of the other townships, in particular Central Lake Township, given that that was the location of the Bailey vote, may be in a different position than some of your other townships. Could you elaborate on that point?
Well, yes, Your Honor. I mean, I recognize that the plaintiff here is a resident of Central Lake Township and voted in Central Lake Township, and of course, my client, Central Lake Township, is aware of that. So, to the extent that there's an actual connection between what happened, if anything, with Mr. Bailey's vote that may have occurred in Central Lake Township, then there's a little bit more in the way of a tangible connection and discovery as to Central Lake Township's equipment as opposed to the rest of the townships. But I don't think that changes necessarily the timing of the discovery, the relevancy of the discovery, given the relief requested in the complaint. I think that's an issue that's applicable to all of the townships, non-party.
Thank you. Let me go to the rest of the township attorneys. Is there anyone that would like to speak? Mr. Bizdak.
No, thank you for the opportunity, though.
Mr. Durman. You're muted, sir. I'm sorry. I think that's on your end, Mr. Durman. There you go.
I'm Your Honor.
All right. Nothing from Mr. Durman. Mr. Cole?
Oh, thank you, Your Honor.
All right. Thank you all. All right. The question before the court is the motion that's been filed jointly by the state and county defendant and supported by a brief filed by the townships writ large. There are several township attorneys here representing the several townships in Antrim County. They've been argued by the defense attorneys who are a part of this case, and also by Mr. Wendling on behalf of the non-party subpoenas or non-party townships, pardon me. And the goal of the subpoenas was to obtain information from the non-party townships relating to the vote that occurred in November. The indication here today from Mr. DePerno is that that was largely the result of the information that was provided by the most recent iteration of expertise and expert review. That review, as we know, was conducted in response to the Halderman report. However, the court is reflecting back on this case when it began, and we discussed information coming from the townships, particularly as it related to the township tabulation machines or voting machines. There was a record made regarding the fact that the county only had one machine that's been discussed here today, and that the actual votes themselves and the tabulating machines were retained by the townships that were not part of this case. Mr. DePerno, on behalf of his client, certainly had the ability to bring them into the case, in particular to bring in Central Lake Township. Mr. DePerno's team, I should say Mr. Bailey's team, did go to Central Lake Township, did receive a voluntary opportunity to inspect the machine in that township, along with, I believe, Star Township and Mansalona Township, if memory serves. This is not a surprise to Mr. DePerno or Mr. Bailey that if there is a township issue, it is something that they certainly were aware of it. Discovery is closed. The plaintiff has already sought to expand this case to other counties, and now it is seeking to expand this case within Antrim County to other townships. Mr. DePerno has indicated or questioned why it is that we are rushing to complete this discovery and complete this case. Well, the court rules require us to move precipitously. I think it's a 6-month period of time that we have to deal with a 3310 motion, which is what's been brought here ultimately, originally anyway. That's why we're moving quickly on this case. I advised the attorneys at the very beginning of the case that we were going to move expeditiously. That meant that the onus was on them to plan their discovery accordingly. There's no doubt in my mind that if Mr. DePerno and Mr. Bailey believed that there was a problem, an issue that could be developed through discovery in the other townships, that would have come in a timely way, given that the case has been going on since November, December of 2020. It did not come. It is now May 10th. We are outside of discovery, and the court believes that at this point, the additional expense, annoyance, work associated with the non-party motions would exceed the value of the discovery that they would produce. As a result, I'm going to go ahead and grant the motion from the defendants to quash the non-party subpoenas from the several townships. As a result, I'm not going to take action on Mr. Wendland's protective order request. If I can get an order from you, Mr. Grill, on that point, please. Mr. Grill, if you would, apparently all of your orders are objected to, but if you would please at least start a list along with you, Mr. DePerno, we can start working on hopefully a master order or set of orders from today's hearings. With that, the township attorneys are welcome to stay, but you're certainly excused. Thank you for your participation.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right, let's go ahead and proceed. The next issue up is, and we're just going to proceed serially through these, and we'll save the joint motion for summary disposition for the end. But the next issue up is an objection to a proposed order. By the way, before we get to that, Mr. DePerno, are we still having issues getting your proposed orders filed? Are you still running into issues with the filing system? I ask that because my staff tells me we don't have those proposed orders that I asked for from you.
Yeah, we filed them twice now. We've provided them to the court through the filing system. And for the record, I did get an email from Tom Hansel, who is the VP of Technical Support at ImageSoft. They are the company that receives the documents when filed and then transferred to the county. And this was Friday, May 7th, 2021 at 11:23 p.m., where he advises me that the court has now been able to apply the upgraded version of the conversion software, and they hope or expect that that will fix issues in the future, but they will continue to monitor it. So apparently the court has been working off a prior version of the software, which has apparently caused problems.
All right. In that case, I'll go ahead and review again. Over the weekend, as I was preparing for these motions, I looked for those matters to try to bring some conclusion. I was not able to find them. My staff was not. But that doesn't mean that they weren't filed. Again, we're dealing with a relatively new technology here, and certainly I know that there have been some issues. It's not your fault necessarily, Mr. DePerno, with filing. And I'm glad to hear that there may be a solution out there, and my staff is listening, so I'm sure that they will be in touch with our technology people, and hopefully we can get that resolved. So thank you for assisting. Let's go then to the objection to the proposed order granting the joint motion for protective order. This objection came from the plaintiff. Mr. DePerno, if you'd like to go ahead and make your argument, sir.
Yeah, thank you. I laid out just where our objections were, and I think this is the objection where we provided the court with some handwriting in terms of what we thought the proposed order should look like, and the pages and the line numbers from the transcripts that we thought corresponded to the correct wording that should be in the order. So that was Exhibit 2 of our objection. I don't want to belabor the point, but I think that lays out exactly what our arguments are.
All right, Mr. Grill, in response.
Yes, Your Honor, we circulated proposed drafts prior to entry. I'm not sure why it is that we can't find out what problems are with the order before it comes in the form of an objection. Be that as it may, my frustration with Mr. DePerno's objections stem primarily on there's a lot of unnecessarily particular objections over language. For example, and I think we pointed this out in our brief, but the idea that plaintiff wants to change the order to read that plaintiff will refile interrogatories that, combined with the first discovery requests, total no more than 20. Wants to change that to plaintiff will serve 17 additional interrogatories in each defendant. I don't know what the difference is there. It's the same effect, and it certainly doesn't mean that our proposed order was inaccurate or incomplete for some reason that would support an objection. Similarly, plaintiff's objection that his prior request to produce were not struck. They were. They had to have been. Otherwise, there was nothing for plaintiff to refile. That was the whole point of refiled discovery requests, was that these were going to be the discovery requests that we were going to be able to respond to. And I think that about covers it. Concerning the time to respond. This is something that plaintiff, and I think just said a moment ago in regards to the protective order, that our responses to his discovery are due today. Now, this appears to be based on something the court said during the hearing addressing this particular motion. However, later on, and there's a section of the transcript that we attached to our response to this objection, the court visits that point. Because of later rulings, the court determines, that's not going to work. Amended this ruling on page 123 to 124 of the transcript, giving the defendants until May 17th to respond. And that is actually, that's correct. So our proposed order is correct. Mr. DePerno's objection is inaccurate. And so that objection should not be upheld.
All right, Mr. Chasm, anything further from you?
Nothing further, Your Honor. Thank you.
Let me go back to Mr. DePerno in response.
Well, I mean, these are issues for I think the court to look at as to which order fits better. But I take objection to Mr. Grill's statement as to why we can't work this out. Mr. Grill had 7 days to submit a proposed order to me, and routinely what he does is he waits until the 7th day, sends me an email at 2 o'clock or 2:30 in the afternoon and says, here's my proposed order. If I don't hear back from you within the next hour, I'm going to file this. So, if we try to if he's trying to place blame on me, I'm offended by that characterization. That's all I have to add.
All right, you've made your recommendation. All right, I'll review these. It looks like I'm going to have a list to review. I'll review and make a determination as to which I believe should be entered. Let's go ahead and proceed to the next, which is the objection to the order granting in part and denying in part the plaintiff's motion to extend discovery. If you'd like to go ahead and make your argument, Mr. DePerno.
I don't have anything to add other than what we put into the objection.
Okay, and that really relates to the concern requiring the notice of depositions or notices of deposition to be sent by April 19th. Is that accurate? That's what you put in the brief.
Yeah,
okay.
I think that's right.
Okay.
Just our understanding of what the court had stated on the record.
Very good. Do you have a response, Mr. Grill?
Mr. Honor, as we pointed out in the brief, that the courts, the transcript shows that the court did in fact make that ruling. We've provided the quoted language in our brief. The court said, Mr. DePerno, I'm going to expect that you file those notices by the 19th. With that in mind, Your Honor, and I know that Mr. DePerno has had a copy of this transcript, I see no basis or reason for this objection to have been filed, and that's why in our response to it, we've asked the court to consider sanctions. That this was an unreasonable objection that should not have been filed.
All right, the court will review and execute in order or amend the order appropriately. Let's go ahead and proceed to just a moment. The next objection, which is with regard to the joint motion to compel. The plaintiff has filed this objection. If you'd like to make your argument, Mr. DePerno.
Yeah, I just stand on our objection as filed.
All right, and do you have anything further, Mr. Grill?
Yes, Your Honor, the only objection Mr. DePerno raised to this particular order was that it didn't include reference to both the plaintiff and defendant's depositions. However, that was because the plaintiff's depositions were addressed in the proposed order we submitted regarding his motion to extend discovery. I tried to treat these orders as I drafted them to address the matters as the court addressed them. Not any particular reason to be tricky there, but again, I don't see any basis for this objection. I think it was unreasonable for Mr. DePerno to have filed it, and we would ask the court to consider sanctions as well.
All right, thank you. And let's go ahead and move to the final two. First, we have the plaintiff's objection to the proposed protective order regarding discovery documents. Mr. DePerno.
Your Honor, I think this is just a continuation of a prior objection that was filed that we'd already heard and that we'd already talked about at a prior hearing. And what happened was when the court asked us to resubmit our proposed order, I refiled what we'd previously filed. And I think the court just took that as another objection. But we've already argued this motion or this objection.
Do you agree?
And the same with the next one.
That appears to be accurate, Your Honor. That was the way it was initially confusing when we saw the objection come in, but then that was the way I interpreted what Mr. DePerno was filing. the court's request for him to submit his proposed order again.
All right, well, this file has been complex, and it's not a surprise that we've had some crossover like this from a scheduling standpoint, frankly. And again, the court will go ahead and review the matters that we have objections for today, and I'll sign or modify as appropriate. I'm also going to sign or modify the 2 remaining objections from a couple of weeks ago, for which we apparently do have proposed orders from Mr. DePerno. And once I've had a chance to review those, as I tried to again this weekend, then those will be executed as well, and we can move past the objections, at least until the next, and hopefully there won't be any more, but if there are, that's fine. Let's go ahead and move to the other motion that is before us, that is not the C4, C8 motion, and that is, pardon me, we do have a note in the record of the non-party township's motion that's already been resolved. Are the parties in agreement that the only other matter today then is the motion for summary disposition?
Your Honor, we also filed our emergency ex parte motion for status conference and to amend motion schedule based on our motion to amend the complaint, which we also filed that didn't get scheduled for today.
All right, the only emergency motion that I saw, gentlemen, and this could be an artifact of the machines that we deal with, was to extend the brief. That's granted, by the way. Mr. Grill, you can go ahead and include that in your master set of orders. The ex parte order that, pardon me, motion that you have discussed just a moment ago, Mr. DePerno, I have not seen. Let me see if I can find that. Just a moment. When did you file that, sir? Today?
I filed it Thursday.
Okay. All right, well, while I look for that document, and again, we may have it here, it may simply not have traveled to us, although we do move emergency motions that are identified as emergency motions quickly to the judge for review. It simply might not have gotten to me yet, given that today is Monday. We had one other business day between the filing and today. I'll take a look at it, and to begin with, however, let's go ahead and start with the C4, C8 motion. This is a motion that's been filed by the defendants. The plaintiff has responded to the motion. There's also been a reply. Again, that reply brief exceeded the page limitation. I've allowed that. And let's go ahead and start with the author of the motion, and that is, I believe, Mr. Grill, if you'd like to make your argument.
Thank you, Your Honor. I know the court has read the brief, and I will do my best not to read it back to the court. I will survey the issues raised. Before I begin, is there any particular issue or anything the court especially wants me to address?
Go ahead and make your argument. I may bring up some issues as we're going through, but one reminder to you, sometimes your voice does cut off. You're apparently, at least as far as I know, the only one in this group anyway that fades out, so you might need to make sure that you're close to your microphone. Please proceed.
Okay, I will scoot up a little bit here. All right, Your Honor, beginning first with the mootness arguments. Our argument here essentially reduces to a simple question. That is, what relief could this court grant to the plaintiff based on this complaint? The complaint itself asks for only 3 things. To conduct this forensic examination, a protective order to preserve records, and the plaintiff's request for an independent audit of election results. Now, there is no question, I think, from the plaintiff that he conducted his forensic examination. Similarly, this court granted his request for a protective order. So those 2 things have been already He's already received that relief. That leaves only the issue of the audit. Now, as we discuss later on in our brief about what plaintiff is entitled to under this, what there does not appear to be much question, though, however, is that the Secretary of State herself conducted an audit of statewide election results, and that is what Mr. Bailey is entitled to as a citizen of the state. Now, the plaintiff may claim that he wants his own audit, but as we've argued later, he's not entitled to that relief. But if we put a pin in that, and we'll circle back to it when we get to the audit claim. There's no other relief that plaintiff requested in this case. So any other claim, all the rest of the claims in his case, other than the audit claim, should all be moot. There's no further relief that he's requesting. Furthermore, there's no relief that this court could grant. The time for a special election to be taken in response to a mechanical defect is long since passed. Similarly, the election results have already been certified, and the time for recounts has long since passed. No candidate or committee requested a recount in Antrim County. The officials who were elected as a result of the November 2020 election have taken office. And at this point, I'm something at a loss to imagine what other relief the court could provide under the circumstances to address any of Mr. Bailey's claims. As a consequence, the absence of the court to grant any relief renders the plaintiff's claims moot. Moving ahead to the standing arguments, as we addressed in our brief, there are three ways for a plaintiff to establish standing. The first is that they can seek declaratory judgment. The second is that they can have a cause of action provided to them either expressly or impliedly through statute. And then lastly, whether they can articulate some special injury or right that is different from the public at large. Now, in this case, the plaintiff's complaint does not seek a declaratory judgment. So the first option is off the table. Moving ahead to whether or not there is a statutory cause of action. First, as the plaintiff acknowledges, Section 861 of the Election Code does not provide a cause of action. It merely preserves the remedy of quo warranto in the event of fraud. So it's not a cause of action statute, so there's no standing for that under that statute. Next, under Section 765 of the Election Code, that deals with whether or not the number of absent ballots sent and received has been posted. That does not create any cause of action, either express or implied. And if the court were to interpret it as creating some type of implied cause of action, which I think no other court has yet done, the class of persons to whom the statute seeks to protect is clearly absent voters. Mr. Bailey alleges in his complaint that he voted in person. So he falls outside of the class of persons who are protected by Section 765, and therefore he has no standing to bring an implied cause of action under this statute. Lastly, the plaintiff lacks standing to raise any of his constitutional claims because, as this court previously ruled, the idea of his standing for a constitutional claim was premised upon Mr. Bailey having potentially his ballot be one of the three that was lost or destroyed in Central Lake Village. That is clearly not the case. Plaintiff alleges in his complaint that he lives in Central Lake Township, not Central Lake Village. His response does not contest or argue the fact that he did not vote in Central Lake Village. Ergo, his ballot could not have been one of the three ballots that was lost or destroyed in Central Lake Village. And Mr. Bailey lacks the ability. The courts have it's long held that you cannot raise constitutional claims on behalf of third parties. And as a consequence, Mr. Bailey has no standing to bring any of his constitutional claims in the case. Moving ahead to our arguments regarding the failure to state a claim, let's start with the audit claim. Because this is the claim that has been brought under Article 2, Section 4(1)(h) of the Constitution. It's a relatively new provision that was added to the Constitution through Proposal 3 of 2018. Now, this particular provision provides expressly, and it's short, so I'll just read it here, that every citizen of the United States who is an elector qualified to vote in Michigan shall have the following rights. The right to have the results of statewide elections audited in such a manner as prescribed by law to ensure the accuracy and integrity of elections. So this is not an open-ended, invent your own kind of an audit situation. This is clearly designed for the person to have a citizen the benefit of an audit being conducted of statewide election results as prescribed by law. Now, in this case, the legislature has prescribed the methodology for an audit for statewide election results, and that appears under MCL 168.31A subsection 2, which provides that the Secretary of State shall set audit procedures and conduct an audit accordingly. She has. There is no reference in section 31A to individual citizens making up their own audit. And in fact, at least 2 other judges of the state have already reached the conclusion that section 401H does not provide an individual right to an audit, or a right to a custom-made audit anyway. The first is in the Janetsky case, which is a court of claims case, which was ruled upon by Judge Murray, in which he concluded very explicitly that that is not that type of individual right, that the right is to have the Secretary of State perform the audit as provided by law. And the next case was by Judge Kenny in the Costantino case, which addressed a lot of the arguments that came up out of the Wayne County election this past year. That case, Judge Kenny determined also does not provide a individual right to a self-selected custom-made audit. That was the Court of Appeals and the Michigan Supreme Court both denied leave in that case. And so as a consequence, no court in this state has yet passed on the idea, or has yet determined that the individual citizen has the right to make up their own audit and set their own procedures. That's just simply not how it works. The plaintiff in his response quotes from Justice Viviano's dissent, but if you read that dissent, what it really basically says is he was arguing why the court should have heard it. He thought that the question should have been considered and reviewed by the court, but he doesn't really necessarily say how he would have ruled on the matter. So there's not a lot of support, even in the dissent, for the position that the plaintiff stakes out in this case. Regardless, the dissent is just that, it's a dissent. The majority of the court, by a vote of 6-1, determined that they did not see anything in Judge Kenny's opinion that presented a question that they thought needed to be reviewed. As a consequence, that decision, I think, stands up pretty well. The plaintiff's personalized audit, the audit that he seeks to have in this case, according to his own terms of Antrim County documents or Antrim County election results, is simply not what is provided by the state constitution. The state constitution provides for a result of an audit of statewide results, not of individual races or individual procedures. And it is certainly not an audit to be conducted according to their own terms. It has to be.
Mr. Grill, is that the reason that when conducting the quote-unquote audit in Antrim County, the secretary did not investigate the individual township issues that had been raised in this case, but rather addressed only the federal issue, that is the election associated with the president?
To an extent, there is something of a misconception there I think probably needs to be addressed. That wasn't an audit per se. That was a hand count that the secretary did to try to reassure the public that the results were accurate, because there was a lot of misinformation flying around at the time. But the audit itself was of the statewide results, which is a results audit with a number of clerks, kind of random sampling, sending in their results and having those reviewed and tabulated, and that was what was conducted. So that was, to one extent, Your Honor, is correct. The idea that that certainly is why we didn't do individual survey of the local results, because that's not what the Constitution calls for. It calls for results of the statewide elections, not local elections. So that is certainly a part of this. Another thing I think is probably worth considering here about the plaintiff's request for an individual custom audit is there are over 7 million registered voters in the state of Michigan. If every single registered voter had the individual right to concoct their own audit and have that performed, the audits would be endless. Every single person dissatisfied with the results, every person who had a question could constitutionally compel their own audit. We would never be done doing them. And instead of showing or preserving that the results were accurate, it would have the opposite effect. Perpetual audits would make it impossible for us to know whether the results were ever actually final. That is why the framers of this particular amendment said that this meant the audits had to be as prescribed by law. There was meant to be some control here, some level of finality. Otherwise, it becomes meaningless. Regardless, nothing in the Constitution provides the plaintiff with the right to the personal or custom type of audit that he requests. As a result, the plaintiff has failed to state a claim for relief under the audit clause, and that claim should be dismissed. Moving ahead to the purity of elections clause, this part of the Constitution, I think, really should properly be viewed as articulating legislative power. If you read what it actually says, the purity of elections clause actually states, I'll just pull it up here, except as otherwise provided in this Constitution or in the Constitution or laws of the United States, the legislature shall enact laws to regulate the time, place, and manner of all nominations and elections, to preserve the purity of elections, to preserve the secrecy of the ballot, to guard against abuses of the elective franchise, and to provide for a system of voter registration and absentee voting. Now, I recognize that in the Taylor case, the Court of Appeals applied this purity of elections provision to the actions of the clerk in that case. So I will recognize that at least it has been applied in circumstances for how elections are administered and making sure that they're administered in an even-handed way. But I do think it's worth kind of highlighting the idea here that I think this particular Constitution provision may have been misinterpreted because it seems to specifically address legislative power, not actual administration of elections. Regardless, even if we consider this, the purity of elections as requiring even-handedness in the administration of elections, in this case, the plaintiff has failed to allege any Antrim County procedures that treated candidates or voters differently. The allegations instead concern inaccuracies in the reporting of unofficial results on election night and in the weeks afterwards. However, even in the complaint, the plaintiff acknowledges that by the time they got to certified results, that they more or less tracked with 2016, and it doesn't appear that plaintiff contests that the final results in which President Trump carried Antrim County were essentially accurate. So what we're left with here is that the purity of elections claim by the plaintiff in this complaint hinges on inaccuracies in the reporting of unofficial results. And frankly, Your Honor, I just see no basis for a purity of elections clause in that. They're unofficial results. They're, by their nature, not the official act of the county.
Mr. Grill, before you go on, how would then a party who felt they were aggrieved as hypothetically or in arguendo a resident of Central Lake Village might with regard to the with regard to the vote tabulation issues, maybe Dominion, we don't know, but the vote tabulation issues that occurred in Central Lake Township and Central Lake Village vis-a-vis the township, how would a concerned citizen go about challenging the purity of, for example, the marijuana election in that village?
Well, the first and most obvious avenue, Your Honor, would be for one of the proponents of the ballot proposal to call for a recount. That'd be the first mechanism that they would have, is the ability to say, hang on. Obviously, and particularly in an election when you're dealing with a difference of one vote, it's surprising to me that they didn't call for a recount.
And this is also the proper mechanism if there's a challenge to the equipment or to the software that's used as well. Is that your argument?
Well, the argument, exactly, Your Honor, because if the argument is that the equipment is faulty, then you call for a recount and you pull out the ballots and you start going through them, 1, 2, 3, 4, 5. Now, usually, when you're doing a recount, it's usually processed mechanically, but if there were a good reason for showing that there was some basis or some question on that point, you could do it by a manual count if you wanted to. I think there would have to be some further findings on that. But the argument, at least, Your Honor, in answer to your question, would be, the first step would be one of the proponents would have had to call for a recount. Alternatively, there would be the avenue under 4545 for someone to say, I have a claim, but the important thing, and I was going to get to this in a minute, what the 4545 argument would be, number one, I think they have to live in Central Lake Village. There would have to actually be a citizen that has a stake and voted in the election and has a stake in the outcome, which Mr. Bailey does not. And then the court could address, in that circumstance of this hypothetical Central Lake Village resident, could they come forward and establish a reason for the court to grant leave for them to proceed in the matter? In other words, one of the things they would have to show is that they need to come forward with affidavits setting forth specific facts, something to the effect of, I saw Clerk Smith, or I saw an election worker stuffing ballots into their jacket, and as a consequence, we need to have an investigation and stop this. That's not anything like what we have in this circumstance. There's, the purity of elections issue, and I think, if you were talking about some kind of a purity elections question, it would have to be some type of procedure established by the county that was tilting the scales. And it's not even with anything in the complaint. The complaint appears to, at some point, or at least it's morphed into something, the idea that there is some type of mechanism in the machines established by Dominion or something. That's not a procedure set in place by Antrim County. And that would be the kind of thing that would have been revealed by a recount had somebody called for it, but they didn't.
All right, I interrupted you. Please continue.
And so I'll kind of take a little bit out of order from the complaint. The next thing I wanted to address was the equal protection claim, because that was the other constitutional argument the plaintiff brings. The plaintiff fails to allege that voters were classified in any disparate way or that any undue restrictions were placed on the right to vote. He simply fails to allege how he or any other voters were treated any differently. That's the essential, the premise of an equal protection clause is disparate treatment, and it's just, there's no allegation that fits that description. Plaintiff instead refers to his vote being diluted, which in some circumstances, as we point out in the brief, the courts have considered the idea of vote dilution as actionable, but in this case, diluted by whom? Normally, when we're talking about dilution, we're talking about racial dilution, that we're divide things up and we're going to put you in a place where your vote is meaningless because you're surrounded by a sea of people who aren't like you. That's not what plaintiff alleges. Instead, again, he alleges that there were errors. Well, any errors in the tabulation results would affect all voters equally. That's not an equal protection claim. That which should be, and again, that's the type of thing that's usually caught and addressed through recount, not through a constitutional action. There's another point that I think is worth emphasizing here, Your Honor, and that's something that was brought up by the district court in the case of King versus Whitmer, again, this past year, and addresses the problem of redressability. The district court in that case noted that the plaintiff's injury, even hypothetically were considered, doesn't entitle them to invalidate other people's votes as well. In other words, the idea here that, well, we're just going to, our remedy here or our relief is to toss all of the votes out, that's not the kind of redress that is contemplated here. At best, what a claim would involve here under the Equal Protection Clause would be to say, discontinue the alleged unconstitutional process. But what process? It's not alleged in the complaint. Again, the plaintiff fails to state the claim. And as a result, his claim for equal protection should also be dismissed. Moving on to the 4545 claim, under MCL 600.4545. This kind of claim requires an allegation of material fraud that would change the outcome of the election. As the Michigan Supreme Court held in the Rosenbrock case, which is cited in our brief, irregularities in conducting the election will not invalidate the election and the action taken unless the result would have been affected. So we have to have some type of allegation here that something occurred, some type of fraud occurred that changed the outcome of the action taker, changed the outcome of the election. This is where things get confusing because it's not entirely clear what action it is that the plaintiff is seeking to challenge. In his response to our motion, the plaintiff doesn't make any reference to the Central Lake Village marijuana proposal. Probably, I think, recognizing that there is an issue there with him not living in that municipality. Instead, the response refers to statewide ballot proposals, proposals 1 and proposal 2. Neither, of course, is mentioned in the complaint. But more significantly, and where we run into a problem for a failure to state a claim issue, is that both of those proposals passed with enormous margins. I think it was something, they were both 80 in the 80s, 84% and 88%. Both of them had a margin of victory of well over 3 million votes. By contrast, the number of registered electors in Antrim County is less than 25,000. So we have a material fraud problem here because there can be no material fraud because even if every vote in Antrim County were determined to be fraudulent, it would not change the outcome of Proposal 1 and Proposal 2. Now, again, plaintiff's response does not refer to the Central Lake Village marijuana proposal, but even if we address that question, we still have problems for a claim under 4545. The first is that plaintiff did not name Central Lake Village as a party to this action. which is required for an action under 4545. And notably, I point out, Your Honor, this has not been corrected in the amended complaint either. The amended complaint does not purport to add Central Lake Village as a defendant. Additionally, there's other problems as well. Even if there's no basis for the court to grant plaintiff leave to proceed in a 4545 claim where he does not live in Central Lake Village. He did not vote in this proposal. This speaks of the kind of vexatious action that the requirements of 4545 sought to avoid. If nothing else, if we're going to have a challenge under 4545 to this particular marijuana proposal, one would expect it to come from somebody who lives in the village and has a stake in what happens in the village, not Mr. Bailey. Lastly, I want to point out that Mr. Bailey's claim for 4545 came unaccompanied by any affidavits, which is, I think, significant as well. If you look at the Barrow case, the court there, I think, was very clear about the kind of requirements that a claim under 4545 requires, where the Court of Appeals stated that the rule is inflexible, that there must be affidavits so full and positive from persons knowing the facts as to make out a clear case of right in such a way that perjury might be brought if the allegation is false. So here again, we need to have some type of allegations from somebody who can say, I saw this happen. This is what occurred. This is why the results are fraudulent. And we don't have that in this case, certainly not in the complaint that was pleaded here. So those are three very significant ways in which the plaintiff has failed to state a claim under 4545. And so we would ask the court also to dismiss that claim as well. That leaves us with the final claim in the complaint, which is the claim under section 765 sub 5. This is a statute that requires clerks who receive absent voter ballots to post or make public the number of ballots sent and received. The problem with this claim, Your Honor, and why it must be dismissed is that the only defendant in this case is Antrim County. The statute places no duty on counties. It makes no reference to counties. The only obligation being placed here is on clerks who receive those absent voter ballots, not counties. And even if we were to construe this generously as referring to the county clerk as an individual officer, the county clerks do not send or receive absent voter ballots. That's done by the local clerks. The plaintiff has not named any local clerks as parties and hasn't done so even in the proposed amended complaint. So there is nothing in the amended complaint that would cure that either. Moreover, even if the plaintiff had named a local clerk as a party to this action, the statute provides no election-related penalty for the violation of this clause. It doesn't invalidate the election. At most, there would be grounds for criminal prosecution if it were shown that the violation here were willful. But that would be something that a criminal prosecution is not the type. A criminal prosecution is not something that the plaintiff himself could bring as a private citizen. As a result, Your Honor, all of the plaintiff's claims fail as a matter of law, and all of them must be dismissed. The last thing I want to touch on very briefly is just to address the effect of plaintiff's motion for leave to amend. And as the plaintiff, I think, mentioned, he has argued in an emergency motion that we shouldn't decide this until the court has a chance to decide the motion for leave. That's not really how this works. The appropriate course of action would be for the court to decide this motion, and then if the court agrees with us and grants this motion, the plaintiff would be given leave to amend his complaint to fix any defects, which the plaintiff has already done. So in this case, I think the appropriate procedure would be to rule on this motion, and then we can address the plaintiff's amended complaint as a separate matter. He's not in any way prejudiced by the court deciding this motion. In fact, the court's determination of these issues, I think, would be significant because it would weigh on how we approach the amended complaint. Does it fix the claims? Are those claims valid? Should they be, is there anything he could do to fix them? Those are things that we would need to know.
All right, thank you, Mr. Grill. Mr. Chasm, in support of the motion.
Thank you, Your Honor. First of all, for the record, I want to state that I join and concur with the arguments made by Mr. Grill with regards to all of the claims under C4 and C8. I just want to make a few additional arguments specific just to the county and specific to the argument regarding mootness. And that's this. As the court is aware, under C4C8, we're looking at the complaint. We're not looking at anything else. And for purposes of the motion, we assume we accept the all well-pleaded allegations in the complaint as true for purposes of this motion. So as has been stated in this case earlier and during this hearing, the relief that plaintiff has sought in this complaint has been the taking of forensic images, the protective order, the seeking of a protective order from this court, and then this nonpartisan independent audit. There's no dispute that as it pertains to the county, plaintiff has obtained the relief of forensic images. He has obtained forensic images of the one tabulator machine that is in possession of the county. He has obtained forensic images of the election management system terminal. And he has obtained forensic images of the media drives and the various thumb drives that were used during the November 3rd, 2020 election. Also, if the court recalls, at the first time this matter came before the court on December 3rd, the county agreed to preserve all the evidence and all the records that were in its possession. So there is a protective order in place that was subsequently vacated upon the request of the plaintiff. So the relief that could have been obtained from the county, all that relief has been provided to the plaintiff. So the only outstanding relief sought in the complaint is this request for an audit. And as has been argued by Mr. Grill, under the constitutional provision, that particular section pertains to an audit of statewide elections, not county elections. But more importantly, looking at the statute, MCL 168.31A, that statute, by its plain language, provides that any audit has to be conducted under procedures prescribed by the Secretary of State, that the Secretary of State trains the county clerks and their staff for conducting these audits in randomly selected precincts in their respective counties. So the Secretary of State randomly selects the precincts in their respective counties, and the Secretary of State supervises the county clerks in conducting of the election audit. So there no legal authority has been presented to the court that says that the county on its own has any legal authority or ability to conduct any audit, regardless of the type of audit that is being requested, any audit. The county simply does not have any authority and ability to do that on its own. And so when we are talking about what relief can be afforded to plaintiff against the county, all that relief has already been provided to the county, with the exception of the audit request, and regardless, notwithstanding any of the arguments that have been made by Mr. Grill and that will be made by Mr. DiPerno on the question of audit. There is no legal authority that is in either the in plaintiff's response that requires the county to be a necessary party for purposes of that audit. The county simply does not have the legal authority to have that audit. So if we are looking at it from that standpoint, from the mootness standpoint, and I'm not foregoing any of the other arguments that have been made on standing and C8 motions, I want to be clear. But if we are going to if you're looking at this case from the county standpoint, this court simply cannot order any further relief against the county that it already hasn't done so. So for those reasons, and for all the other arguments that Mr. Grill has made regarding standing and failure to state claims, we are asking the court to dismiss the county with prejudice from this lawsuit.
All right, thank you, Mr. Chasm. Mr. DiPerno, let's go to you in response.
Thank you, Your Honor. First, I want to address the overarching idea or concept that the Secretary of State and the county are raising, that pursuant to their arguments, there's literally no mechanism available to someone like Bill Bailey to challenge the results of an election in his county when we have massive evidence of fraud that occurs in the county through these tabulator devices, the Dominion voting system, and fraud that occurs by the Secretary of State herself and the county clerk in terms of their failure to properly investigate or to certify what is clearly a fraudulent election. And this is fraud from the top of the ballot all the way down to the proposals 20-1 and 20-2. This includes the school board elections, the election for Michigan Supreme Court, and all of the township elections, the local elections. This includes the elections for the trustees of the universities in our state. Their overarching argument is that there's literally no mechanism for anyone within the county who is not an actual candidate to challenge any election where we have this type of fraud. And this is unprecedented what we're dealing with. We're dealing with a voting system where we have submitted substantial proof to the court that these voting systems are able to switch votes, to manipulate votes, and it is so easy to do. We've shown the court how we can do it, and in our filing this morning, we've shown how the actual fraud works and the subversion of what actually occurred. So I want to at least give the court that as a overall wide breaching argument that the Secretary of State and the county are making. Their first argument is the claim of mootness, and we certainly disagree that our claims are moot. This all hinges on the idea of an audit and whether Mr. Bailey is entitled to conduct an audit in his county. Mr. Grill today, for the first time, we haven't heard him say this, but he did say it today. He stated, let's be clear, the December 17th hand recount was not an audit. It was simply a hand recount. They didn't inspect any ballots other than looked at the presidential election. We didn't look at any of the down ballot races. We didn't look in any way to ensure or preserve the idea that Bill Bailey's actual ballot counted. And we've got significant concerns, obviously, and that his ballot did not count in this election.
Can we resolve one issue? Mr. Bailey, did he vote in the village of Central Lake, or did he vote in Central Lake Township?
He votes in the Central Lake Township, not in the village.
All right, so he did not vote then in the issue that I was concerned about initially, which was the adoption of the marijuana ordinance, given that there was a 1 vote difference and approximately 3 votes may have been spoiled in the counter recount process. Is that accurate?
That is not accurate. He did not vote in the village, but the 3 votes that were spoiled are not related to the village.
Okay.
We're talking about the actual township, and Judy Koslowski declares that their team analyzed both rolls, or ASOG did this based on their conversation with Judy Koslowski, and determined that the vote tally in Central Lake Township did not match up, and that there were 3 votes missing after 3 votes were damaged. That is a substantial issue. That is not a village issue. So we have to be clear about that.
Before you go on, let me make sure that I have it clear in my head. So Mr. Bailey's vote, by your analysis, could have theoretically been one of the 3 votes that may have been spoiled in Central Lake Township. However, as a resident of Central Lake Township, he did not vote with regard to the Central Lake Village marijuana ordinance. Is that accurate?
That's correct.
All right, please proceed, Mr. DePerno.
Mr. Grill acknowledges there was no audit in this situation. He speaks broadly of an audit across the state of Michigan and tries to declare that the Secretary of State conducted a statewide audit. All she did in reality is conduct an audit of, she conducted a hand recount of 18,000 ballots in various townships across the state of Michigan, none of them being an actual audit. And when we look at her own publication titled Post-Election Audit Manual, that describes an actual audit procedure and requires the examination of election notices, the way people were trained. And we've already agreed, I don't think there's any dispute of fact in this case, that Secretary of State Benson did not train people across the state on the Dominion voting system. So that would be certainly an issue. We're entitled to look at the e-poll book security, the test deck procedures, military and overseas voter applications. All of these things are described by Secretary Benson in her manual of what a post-election audit is. She states that a vital component to a successful election is the conduct of the preliminary and public logic and accuracy testing. We've got no indication that that ever occurred in Antrim County. She says we should review the applications to vote. We've got no indication that that was reviewed in Antrim County. She says to review the completion of a receiving board checklist on election day. She goes on and on and on about the actual audit procedures, ensure the number of ballots tabulated already shown the court through one of our subsequent filings that the number of voters that are reported by the Secretary of State as having voted in Antrim County is 1,060 people short of what actually occurred at the hand recount. So we know, and that's why we say we've discovered 1,060 phantom ballots. Phantom ballots appear to be ballots that are not in any way connected to a voter. And that's significant in this 2020 election because we shouldn't have more people voting in the county or show up in the hand recount than the Secretary of State shows actually voted. So that would be part of an audit to discover how that occurred or why it occurred. She goes on to determine many other things to ensure a master card is available for each voter. We have no indication that that happened. Does the number of spoiled ballots in the spoiled ballot envelope equal the number of spoiled ballots listed in the poll book? We know that that didn't occur. We know that the spoiled ballot numbers are incorrect, or potentially incorrect, I should say, based on what we saw at the hand recount and the video that was posted and that we linked to in our response brief, where the gentleman shows that the number of signatures, about 148 signatures in Central Lake Township, are all filled in by the exact same handwriting. The explanation we got for that at the time was that there would have been spoiled ballots and that Judy Koslowski or someone on her staff would have then hand wrote all of those signatures in, and that's why they looked the same. But on further inspection that day, there were not 148 spoiled ballots for Central Lake Township. So that's a problem. And it demonstrates why we actually need an audit. So for these reasons, we say the claims are not moot, Bill Bailey is entitled to an actual audit of the election. But these arguments that we hear today state that he's not, and that there's no mechanism for a guy like Bill Bailey to come to this court in any form, apparently. No matter what you put into a complaint, there's no mechanism for Bill Bailey to be entitled to an audit within his county to challenge the election results where we have significant fraud like this.
Well, Mr. DePerno, it is a relatively new statute, but has any court had a chance to weigh in on the issue and determine, any appellate court, and determine that the right of audit is in fact an individual right and extends beyond statewide ballots to local votes as well?
No, there's no appellate court that has made this determination yet. The Michigan Court of Appeals has not decided it. The Michigan Supreme Court has not decided it. This is an issue of first impression that we're dealing with when we deal with the 2018 amendment to the Constitution that states that every citizen of the United States who is an elector qualified to vote in Michigan shall have the following rights. And under H, the right to have the results of statewide elections audited in a manner prescribed by law to ensure the accuracy and integrity of elections. That is a brand new constitutional provision, and the Court of Appeals has not taken any case yet. Mr. Grill talked about the idea that in the Castantino case, that the Court of Appeals did not accept that case on appeal. And then the Michigan Supreme Court did not accept that case on appeal. They simply didn't take the case. And as we see, I think or Judge Viviano's dissent is so enlightening, and I give it much greater weight, obviously, than Mr. Grill does, although I concede that the issue that the Supreme Court was dealing with was whether or not they should take the case. But Judge Viviano's decision is so enlightening when he states the provision is self-executing, meaning that the people can enforce this right even without legislation enabling them to do so, and that the legislature cannot impose additional obligations on the exercise of this right. We read this constitutional provision to give Mr. Bailey the absolute right as a citizen, as someone who voted in the election, to have the results of statewide elections audited in such manner prescribed by law. Statewide elections means, I believe, any election that's across the state. So if we have the presidential election, the election that John James was in for senator, congressional elections, all of these statewide elections could be audited by Mr. Bailey, and it's self-executing, and it simply says in a manner as prescribed by law. We don't know what that means, but Judge Viviano seems to suggest that they can't actually limit the rights given to him in the Constitution.
So, Mr. DePerno, is Mr. Grill's argument that interpretation would grant a right to 10 million plus citizens in the state of Michigan to challenge an election and create chaos, perhaps, as a result, if they don't like the result of a particular election?
I believe it gives every citizen a right to challenge the election, the statewide election. That's
so
what
the statute, at least as currently drafted and as you interpret it, which is of course following the referendum, would have the net effect potentially of creating hundreds, if not thousands, of lawsuits throughout the circuit court, and perhaps the Court of Claims, following a general or even a lower level election at statewide. Is that a fair analysis?
I believe it is. I mean, I understand that that's a large number of cases, but we also have to consider the practical effect of who would do that. I mean, who can afford to do it, number one. There's all kinds of practical effects that come into a decision like that, but there's nothing within this statute that limits anyone's right to challenge the election. And that may be an issue for the Michigan Supreme Court to deal with, but Judge Viviano is quite clear that there's—
Justice Viviano, by the way.
I'm sorry, my apology. Justice Viviano would say that the people can enforce this right even without legislation enabling them to do so, and that the legislature cannot impose additional obligations on the exercise of this right. People have the right to challenge the election, and it's so important in this election because we have so much fraud, as we've demonstrated just in Antrim County. We now know, I would say conclusively, what happened in Antrim County on election day. We know how these votes were flipped. This wasn't human error. This wasn't the safest election in history. This was a significant problem where the Secretary of State, as we allege in our amended complaint, and the county official, Cheryl Guy, would have had knowledge of what was going on, or at the very least, they are grossly negligent in their failure to investigate, because over a period of essentially 6 months, we've discovered what happened by examining these forensic images, running tests on these forensic images, and mock elections to show that what happened on November 3rd in Antrim County was not human error. This is a significant problem that the country faces, and to discard this case or discard Mr. Bailey's constitutional rights to ensure fairness and accuracy in this election would essentially mean that we're permitting fraud to occur in any election, fraud as significant as this, fraud through actual manipulation of voting machines. How can anyone trust the system in the future? Mr. Bailey didn't vote last week in the last election because he no longer trusts these voting machines. And it's significant because we've now proven how the vote manipulation happens in these machines. If you have a vote transfer from Jorgensen to Trump and Trump to Biden, then Biden's vote has to go somewhere. Just through the programming of the machine, it has to fall within another category. And in this case, it didn't. It didn't go anywhere. It was zeroed out through an undervote. And our tests show that if that is the mechanism, or that's the programming that happens, or that's the excuse given to us by the Secretary of State or the county, that can't happen because there would be a massive error triggered by the system which would shut down the election. And in order to stop that, the vote on the backside, in order to stop that, the programming on the backside dealt with those errors and subverted the election, allowed the election to continue despite these errors that should have shut down the election. That's subversion and that's fraud. And people knew about it. Officials knew about it within the state of Michigan. They had to. They had to know this was happening within our voting system, and they failed to act. And that directly affects not only everyone in the state, but certainly Mr. Bailey's constitutional rights under this provision. But if we read the constitutional provision narrowly and say Mr. Bailey doesn't fall within that category because potentially too many people could file lawsuits, then we're eliminating his right, and we're eliminating what all the people in the state of Michigan voted for in 2018 when they passed this amendment. They were clear. The language is clear. They want people to be able to challenge the elections to make sure that elections are fair in this state. So based on that, we don't think our claim is moot at all. But certainly we haven't got an audit. We don't have an audit. There's never been an audit. There's not an audit provided by the county. There's never been an audit, as Mr. Grill even admitted today, not an audit provided by the Secretary of State. And so their argument appears to be that you just can't get an audit of a county election. Can't certainly get an audit of a down ballot election, especially when we have allegations of significant fraud. The next issues they brought up deal with standing. The standing under 168.861, we recognize that's a savings clause, but we filed that in conjunction with 4545. So I don't see that as an issue. The standing under 168.765, I think the defendants are misguided on this argument regarding the absentee ballots. There's nothing within section 765 that states that you must be an absentee voter in order to bring a challenge under section 765. And then regarding the constitutional claims themselves, we've already addressed that Mr. Bailey was a voter in the township of Central Lake. We already know there's an issue that 3 ballots were destroyed. He has to have a mechanism in order to challenge the election where he voted and his township supervisor acknowledges that 3 votes were destroyed, and they didn't show up in the actual revote count. We know that because the tape rolls show 1,494 total votes initially, and then roll 2 says 1,491. So those 3 votes are gone. They don't appear in the next vote roll. So we know that's an issue, and that has to be addressed in some way. He has to be able to get clarity on whether his vote counted.
Mr. Paterno, does it have to be, again, your argument, I think everyone would agree with that every vote should be counted. We expect them to be counted, but we also recognize that sometimes things do happen where a vote is spoiled. And assuming that your clients was one of those 3 spoiled, wouldn't the next issue be whether or not there was a material impact on one of the races in Central Lake Township based on the non-counting of a spoiled vote? And then, well, let's just leave it there, based on the non-counting of the spoiled vote.
No, well, first, I guess I take exception to the idea that everyone thinks that everyone's vote should count. From what I've experienced throughout this election cycle, there's a lot of people that don't care if everyone's vote counts. Certainly what we've proven regarding the Dominion voting system shows that there's a lot of people that like these machines, and there's a lot of Secretary of States out there, county officials and others, who don't care if your vote counts because they're willing to subvert the vote. And we've proved it. If nothing else comes of this lawsuit, people need to understand that what we've proved so far, and I say it again, without getting discovery from the defendants in this case, what we've proved is that the vote was subverted. We know how it happened in Antrim County, and we know it was fraud. Now, that's regardless of whether our case continues. People have to know we did that. So, in terms of this argument that we can only provide Mr. Bailey justice if we can show that there'd be a different result, I think is the question you're asking.
It is.
We don't know that. You can't tell me that. Mr. Grill can't tell me that. No one can tell me what the actual ballots say until we look at them. Because as I've demonstrated, I can show you, and my experts can show you, how to flip votes at the tabulator and how to close out an election and have that tape print out, that tabulator tape print out with the wrong election results. And in that situation, if everyone understands how elections occur, once we close out an election and print off that tabulator tape, your county canvassing board takes a look at that tabulator tape. They say how many people voted, and it could be 100, 200, whatever it is. They then compare that to the poll book. If those numbers match up, they'll certify the election without ever looking at the paper ballots. So no one can tell me, based after the evidence we've shown, that there wasn't a change in the election, or that Mr. Bailey's vote didn't count one way or the other, or that there weren't 1,500 votes subverted in any one election to change any one election. You can't tell me that in proposal 20-2 or 20-1, where Mr. Grill says overwhelmingly across the state of Michigan, people voted 80% in favor of these, roughly. Who's going to tell me or Mr. Bailey or other citizens of this state that 80% of the state of Michigan decided or thought to give their rights for land and oil lease to the state of Michigan under 20-1? I don't know if that's true. He doesn't know if that's true. No one knows what the actual votes were in this case. We're assuming that these tabulators print off correct paper out of the tabulator, and I've shown everyone that's not true. So this argument of we can only provide Mr. Bailey a remedy if we can show that his vote would have somehow affected an election once we look at the grand total of the number of votes cast, that's a low-hanging fruit argument, and it assumes that everyone's playing fair and no one's subverting the election through these voting machines, and it's just not the case. So we just can't say that. I understand the Secretary of States across the country want to make that argument and plead to the people everywhere that elections were fair. And we've shown, just in this small little case in Antrim County, it's just not the case. That brings us to MCL 600.4545. That statute allows a person like Mr. Bailey to bring a lawsuit whenever it appears that material fraud or error has been committed at any election at which there has been submitted any constitutional amendment, question, or proposition to the electors. And we satisfy that quite easily. This lawsuit was filed within 30 days. Mr. Bailey is a citizen, and there were, within this election, constitutional or propositions, at least. There were proposition 20-1 and 20-2. He satisfies that under 4545. The other issues come, we've dealt quite a bit, I think, today with the argument of the constitutional amendment under Article 2. We very clearly think that Mr. Bailey has the right under that constitutional provision to audit any statewide election. We know that there's been no audit done in this case. We also know that MCL 160.31A2 actually limits the Constitution in its language. And that statute says the Secretary of State shall prescribe the procedures for election audits, a key word, that include reviewing the documents, ballots, and procedures used during an election, as required by Section 4 of Article 2 of the Constitution. It's even that statute recognizes there has to be an audit, and we would review the documents, ballots, and procedures. And I can guarantee you that in no event has Secretary of State Jocelyn Benson done anything even close to that. At the very most, she's done a hand recount of 18,000 ballots. She's done no audit. She's reviewed no documents, no ballots, and no procedures at all. It just never happened. She's also provided no training. This statute requires, we believe, as we wrote in our brief, this statute requires the Antrim County Clerk to perform the audit under the supervision of the Michigan Secretary of State. It further orders the Antrim County Clerk to report the results of the audit to the Secretary of State pursuant to MCL 160.31A3. So if you think about that, all that happened here on December 17th was the Secretary of State came in to Antrim County, where she first declared there would be an audit based on her notices to everyone, there's going to be an audit. Then the day before, she changed that to a hand recount, which was conducted by the Secretary of State. And nothing was done by the Antrim County Clerk at all. It was all done by the Secretary of State. So the Antrim County Clerk never performed any type of audit, and certainly didn't perform any audit under the supervision of the Secretary of State. In fact, the Antrim County was just a bystander on December 17th. And certainly the Antrim County Clerk didn't report any results of the audit because there was no audit. So we've even failed under 168.31, even if we adopt the Secretary of State's argument that somehow 168.31A is constitutional on its face, number one, and whether or not the Antrim County even performed its duty under that statute. Again, we've gone through Justice Viviano's dissent. I think it's so important. Again, I can't emphasize enough how we have to look at that dissent that he issued to understand what he's actually talking about in terms of him saying that we should have taken the case, the Michigan Supreme Court. They didn't, but that's why we're here as a case of first impression. The purity of election clause, it seems quite easy to me that the purity of election clause has been violated in this situation. Mr. Bailey's constitutional rights are violated. This election is a fraud. There is subversion. We've shown it. We've shown it without getting discovery from the Secretary of State. We've shown it just through our testing of how the Dominion voting system works. There's no way a legitimate company, a software company, would ever write code this way. This system allows people too easily to subvert any security protocol that might be there, go directly to the Antrim County database and flip elections right there using that Microsoft SQL database management program that, by the way, shouldn't even be there. It's not a certified program under the Election Commission, shouldn't be there. That use of that program on the Antrim County system that we discovered should actually invalidate the Antrim County election management system. We heard a lot today, interestingly enough, about how they're so concerned that my team coming into Antrim County would somehow do something to their equipment that could invalidate warranties or make elections insecure. And yet here in Antrim County, sitting in their own system is an unauthorized program called the Microsoft SQL Database Management Program that shouldn't be there. And they're criticizing us as if we are going to do something to their election. They're using a machine right now, and they used it in the November 20 election. They're using this program that decertifies their entire election. Moving on to the further arguments that Mr. Grill made on 600.4545 and 168.861, Mr. Grill stated that any irregularities in the election would be revealed by a recount of the actual ballots. I asked Mr. Grill, opposing counsel, or the court, or anyone, show me one single election from November 3rd, 2020, where anyone's been able to actually do an audit of the ballots. There's one place that's occurred. It's happening right now in Maricopa County. Otherwise, no one is allowed to do it. These Secretary of States and these county officials tell us over and over again that if we want to verify that there was no fraud, what we need to do is just pull out the ballots and look at them. And every time anyone across the country says, let me look at the ballots, they immediately will fight you. We even have now talk of the Department of Justice coming into Maricopa County to try to shut that audit down. They don't want people to look at ballots. Secretary of State Benson doesn't want people to look at ballots. Antrim County Clerk Cheryl Guy doesn't want people to look at ballots. And they don't want people to look at them because we believe that when you look at them, they will prove our findings. They will help prove that what we've disclosed here through our investigation of the forensic audits, through the testing we've done, that we'll show you that those ballots aren't correct. They don't match up to the actual results. In some cases, there's probably ballots that have been photocopied. They're not printed on the correct paper. The signatures aren't going to match up with absentee envelopes. So let's abuse ourselves of the fact or the idea that if we want to inspect an election or to verify results, we should just look at the ballots. No one wants us to do that. The Equal Protection Clause, I believe, is an easy argument. The same argument was rejected in the same argument by the Secretary of State was rejected in Ryan versus Benson Court of Claims case, where the Court of Claims stated, quote, here, because plaintiff has a cause of action for a violation of the Equal Protection Clause and their rights could be substantially and detrimentally affected differently than others within the general public, they have standing. What they're talking about is the dilution of votes, and Mr. Bailey certainly suffers from that. He suffers from, number one, whether his vote was counted in the first place, and otherwise the dilution of votes. He certainly has standing under the Equal Protection Clause. And more importantly, as we describe in our brief, the Supreme Court has readily endorsed the theory or the class of one theory. We went through that in our brief. I'm not going to repeat that. MCL 168.765, Mr. Grill states that there's no penalty under that provision. Even if we have a valid claim, there's just no penalty, and therefore our claim should be dismissed. So I ask, what's the remedy? What's the remedy for violation of the Constitution? What's the remedy for violation of civil rights in a case like this, where we're using voting machines that are absolutely fraudulent, and where the Secretary of State and the county clerk either unwittingly or by gross negligence or with knowledge actually allow this to happen in Antrim County? We talk about the idea of, oh, well, maybe the county prosecutors might do something. I don't think there's any realistic thought or idea that I haven't seen any evidence that anyone's going to prosecute anyone. I mean, we've got clear violations across the country of voting fraud. Even in Antrim County, we know now that on November 4th at 11:03 p.m., Cheryl Guy deleted the system files from the election management system. She's admitted that she directed her staff to do that. And based on what we filed today, this subversion, this idea of subversion falls right in line with that. I could guess that we would now know why they deleted those files, because it shows directly how they subverted the election, why the machine didn't shut down when there was massive error rates that should have otherwise shut down the machine. So there has to be a remedy for Mr. Bailey. Finally, Your Honor, we have filed a motion to amend our complaint. Our amendment deals with a lot of these issues that the Secretary of State and Antrim County complain about. I did see, I just looked up that we did get a notice of hearing that ex parte motion would have been heard today. That notice of hearing was issued out earlier today. But our motion to amend was clearly filed 7 days prior to this last Monday. It should have been put on the schedule today. It wasn't. It's not. It's next Monday. I'd at least request that we hold any decision over until next Monday so the court can consider both motions at the same time. I think that would be proper and efficient for everybody. Does the court have any further questions for me?
I don't, thank you. And I did locate your emergency motion, by the way, earlier. I did have a chance to review it. And I understand your argument with regard to next week. We'll talk about that in just a moment. But before we do so, let's go ahead and get a response from Mr. Grill, if you would, please.
Thank you, Your Honor. During my original argument, the court had asked what citizens could do if they felt aggrieved by the election. And I don't know if my answer was complete, and I just wanted to make sure that the court had the benefit of additional information. Citizens, in addition to, as I discussed, the ideas of whether recounts occur, and if citizens might have the option or a remedy if they had an actual interest in the case to bring an action under 4545. But in addition to that, citizens can also petition for a special mail election, and there is also the option for a special election if there is an occasion of machine error. That is provided for under MCL 168.836. So there are remedies available, but they don't neatly apply here for the reasons that discussed. Most notably, that the time for special election has already passed.
Mr. Grill, you're cutting out.
I apologize, but as I was saying, the problem, Your Honor, and why that there is an issue here that the time for those special elections has already passed. So that is certainly an issue for Mr. Bailey, but there are options available to citizens. I also want to clarify the hand count that we did for the presidential election in Antrim County was not the entirety of an audit, but I want to be clear that that Antrim County was included as a set for the entire statewide audit of results. So there has been, and Antrim County was part of that audit as a whole, but it did not consist entirely of that hand count. And that's why, to whatever extent Mr. DePerno wants to read the manual about why that was not an audit, it's because there's a bigger picture there. There are more pieces to that puzzle. Regardless, the audit was conducted. The part about Mr. DePerno's arguments where he talked about why, what Secretary Benson did was somehow inadequate as an audit under the statute, that would be an argument for mandamus, to say that the secretary needs to perform her legal duty correctly. That's not what plaintiff brought here. He's seeking to bring his own personal audit conducted by him according to his own standards. And that's simply not provided for by the Constitution. In fact, that's contrary to the plain language of the Constitution. I read it before, I don't want to quote it again, but basically the Constitution says you have the right to the results of the results of statewide elections audited. What the Constitution doesn't say is to conduct an individual audit. The Constitution doesn't say that they have a right to their audit. It doesn't say that they have a right that they have the right to conduct an audit. It says you have the right to have the results of statewide elections audited. There's a possessive difference in the language being used by the Constitution that I think is significant. And it's one of the areas where Mr. DePerno's argument falls apart, is because the individual citizens simply don't have the right that he's trying to create. Also, and we addressed this in our brief, but under Section 31A, audits are not recounts. They do not change the results of any election. So even if the court were to say that Mr. Bailey gets the right to his own audit, it doesn't change the outcome of the November 3rd election. I would also point out to the court that, and this is not really germane to our motion, but there were a lot of things that Mr. DePerno brought up, and I do think it's worth pointing out that we did do the hand count of presidential votes in Antrim County. Mr. DePerno was present for that hand count, and that the numbers of that hand count essentially matched up with the official results that were certified in Antrim County. So to the extent that he says that no one has ever validated or verified any of these election results, that's patently untrue. I would also point out that citizens can FOIA ballots. They're public documents. Mr. Mr. Bailey doesn't have that option because he's a plaintiff in this lawsuit, and once litigation is invoked, it's no longer FOIAble for him. But any other citizen can certainly avail themselves of that process if they have curiosity and wish to go through and count individual ballots. Mr. DePerno asked what the remedy was for a violation of 765. Well, I guess potentially mandamus. If you have a local clerk that's refusing to post their number of ballots sent and received, you could go to the court with an emergency motion to say, we want them to perform their clear legal duty. Alternatively, if they're willfully refusing to perform their duty, they could be subject to criminal penalties. But again, that's not for Mr. Bailey as a private citizen to regulate. But regardless, it's certainly nothing in 765 impugns or affects the validity of election results. If some local clerk doesn't post the number of ballots correctly, ballots are still there. The results are still the results. It doesn't invalidate the election. Lastly, Mr. DePerno just suggested that the court hold on this motion before until it has a chance to review his motion to amend. Again, I submit that that's not how this is supposed to work. If the court were to do that, Mr. DePerno could tomorrow, or Mr. Bailey could tomorrow, withdraw his motion for leave to amend the complaint, and none of these issues would be resolved, and we'd be stuck still with the original complaint in this case. I think the appropriate course of action is to have the court rule on our motion, make determinations on the legal sufficiency of the complaint, and then if, as we maintain, the entire complaint should be dismissed, the plaintiff will have the opportunity to argue about why he should be given leave to amend after we've had the opportunity to explain why the proposed amendment would be futile. And then lastly, I know the court knows this, but I'm also cognizant of the fact that there are many people watching this hearing, so I want to make it abundantly clear that the plaintiff has not proven anything. All of the factual matters that Mr. DePerno raised in his argument are disputed, but they're not pertinent to this motion because our motion is based purely on legal questions and the legal sufficiency of the complaint. If necessary, there would be some future day where we would address the factual problems with Mr. DePerno's arguments, but we're here today to talk only about the legal sufficiency of the complaint.
All right, thank you, Mr. Grill. Mr. Chasm, do you have a response?
I have nothing further to add, Your Honor. Thank you.
All right, thank you. My plan ahead of the argument today was to take some time to prepare a decision, which I would provide orally to the parties most likely next week, since we are all scheduled to be together. Assuming that I'm able to complete my work this week, given my schedule, then that is still my plan. I expect an oral decision. Again, assuming something doesn't come up this week, I do have a trial that I need to conduct on Thursday and Friday, but I should be able to complete most of this work over the next few days and hopefully wrap it up over the weekend. So we would be discussing it, or you would be receiving my decision when we next meet. Is there anything else that we need to address for today? Let's start with the plaintiff, Mr. DePerno.
Nothing from the plaintiff, Your Honor.
All right, Mr. Grill.
There is a matter I do think I need to raise, Your Honor. We have a number of things pending this week, a large number of depositions related to the court's previous rulings on experts and getting those depositions done. The problem that we run into now, though, is that with the plaintiff's proposed amended complaint, it seeks to add a new party, election source, for whom neither I nor Mr. Chasm would be capable of representing in any of those depositions. So we run into a problem now, like if we're going to proceed and, if at some point the plaintiff were given leave to amend his complaint to add that new party, all of the discovery that we would be engaging in this week would be rendered basically worthless because there would be new claims that aren't addressed in the depositions and a new party that would want to be heard in them. So my suggestion would be to the court that all matters be stayed until the court has an opportunity to review the motion to amend. Otherwise, we're going to be doing all of this stuff twice. which I think would be prejudicial, and it would be kind of pointless.
Mr. DePerno?
I think we got Mr. Grill's motion or his deposition scheduled. If he wants to not conduct those depositions, we've heard a lot about this idea that discovery's over. I don't disagree that there's expense that will be involved and that people would like to avoid that, I guess, but I don't know. I'd leave that to the discretion of the court. I can't really, without consulting with my plaintiff directly, I don't know how to answer that.
All right. Well, and Mr. Chasm, do you have anything to add to that particular request?
Thank you. I just want to point out also that in addition to depositions that are scheduled this week, plaintiff has also noticed the depositions of certain county officials next week over 2 days. So I think we are going to run into the same issue about whether an additional party who has been named, whether they would have the opportunity to attend those depositions.
And with regard to the settlement conference that was originally scheduled for tomorrow, that's been adjourned. Is that right, gentlemen?
We have reached a stipulation on that, Your Honor, that we'll be filing later this afternoon. We didn't have the chance to do it this morning once we got all parties' consent.
All right. That stipulation is what?
I will have to pull it up, Your Honor. It's been a day since I've looked at it. 1 second here.
I would note that we did receive a Zoom invitation from the court for tomorrow's settlement conference.
I found it. Okay. I'm opening it. There would be a final pretrial settlement conference for a date not sooner than September 1st. And that the trial will be scheduled for a date not sooner than October 1st. There are some other dates for trial briefs and whatnot, but I think that the court was asking me about the pretrial conference.
All right. As far as the settlement conference tomorrow goes, that is adjourned pending the court's receipt of the stipulation from the parties that we had discussed earlier. That's number one. With regard to the request from Mr. Grill, I think it makes sense for us to adjourn, let's say continue, the depositions that have been noticed this week. There will be no need to reserve those deposition notices. The deponents simply need to be contacted with new dates and times. Those new dates and times will be determined after we conduct the hearing on the motion that's been filed by Mr. DePerno to amend next week. Mr. Chasm, with regard to the county officials that have been set for deposition next week, those depositions will stay on, again, pending the decision of the court with regard to these motions, including the motion for summary disposition, which I really hope to be able to give you Monday, and I'm going to do everything I can to be able to do that. Does everybody understand what I've just indicated, Mr. Grill?
Yes, Your Honor. I believe that the depositions that we had noticed for this week will be continued at some later date, and that will be consistent with the court's prior rulings. We've got to get these done, but we're going to have to pick a new date to do it.
Accurate. Mr. Chasm, you agree with Mr. Grill, and do you understand my ruling here?
Yes, I just want to point out that as the notice that we received for the hearing dates is Tuesday, May 18th, and not Monday, May 17th. And the first deps are scheduled for Tuesday, May 18th for my clients. So I understand the court's order that the court at this point is saying that those depositions for the county officials next week are not going to be continued and will stay on. But as of now, the motions have been all scheduled to be heard on Tuesday, May 18th.
All right. Well, you didn't tell me that. So if they are all scheduled on the same day that we are expected to be back here together, then those county motions will have to be continued as well. Thank you for letting me know that, Mr. Chasm. First, I assumed that we were going to meet on Monday. It sounds like we're meeting on Tuesday. And second, the depositions are going to be conflicting, so there is good cause to continue those to another date, and that's what we're going to go ahead and do.
Your Honor, I've just been, I've been informed that we have depositions of state people on the 17th and 19th, I'm sorry, the 17th and 21st as well. The 21st, I suppose, could stay on pending the court's decision, but the 17th one would have to be moved as well.
That would be before my decision, which we assume is going to come on the 18th. So as a result, that would be correct, Mr. Grill.
All right. Thank you, Your Honor.
All right, Mr. Chasm, you understand my ruling today on these points?
Yes, that the depositions are scheduled for Tuesday, May 18th are continued, but not for Wednesday, May 19th.
That's correct. Mr. DePerno, do you understand my rulings on these points?
Yes, 18th are continued, 19th are not, 21st are still on. I think, okay, got it.
That's accurate. All right, thank you all for your arguments today. I will do some homework and hopefully we'll have a decision for you on the 18th.
Thank you.
Thank you.
Your Honor, if I may, while we have everyone present, there has not been a deadline set for the plaintiff's rebuttal expert reports to be produced to the defendants. It's just been oversight. So I don't know if the court wants to set one or not.
All right, well, this is a new issue. Mr. DePerno, are there reports that are going to be produced by your experts?
There are,
Your
I
rebuttal
actually,
experts.
right, I thought they were to be produced by the 24th of May is what I thought.
My understanding was that was the list of them to be named. But if that's the date that Mr. DePerno is comfortable to produce any reports to us, I think that would be okay. I just wanted to make sure that there would be a date for that because otherwise it's kind of.
Sure. Mr. DePerno, does the 24th work? It certainly seems to make sense given the deposition schedule that we have out there.
Yeah, I thought, yes, that makes sense, the 24th.
All right, Mr. Grill, if you could add that to your list, please. Mr. Grill, I'll expect a set of orders from you or proposed orders. And let's give Mr. DePerno more than an hour to review them, please.
I generally do try, Your Honor, and I will.
I understand. Let's go ahead and get those in, hopefully by stipulation, if not under the 7-day rule. Okay, thank you all.
Thank you.
Thank you.
Thank you, Jessica.